You're listening to Best Practices with Kenny Berger. On this podcast, we talk with the country's top trial lawyers about their approaches to every aspect of practice, from case selection to closing argument. And welcome. Our guest today is Karen Zahka, and Karen is a, now at this point, nationally renowned trial lawyer, part of the TL4J family, and does a lot of work east of the Mississippi, but also travels out west of the Mississippi. And Karen, welcome to Best Practices.
Thank you. Thank you for having me. I'm happy to be here.
Yeah. All right. Where are you today?
I am physically located in Massachusetts, in my home. So most of my work is done remotely, but I fly out for, depositions, hearings, trials if needed.
And you're barred in a ton of states, right?
Yeah, I'm licensed in Mass, New Hampshire, Iowa, Nebraska, Oklahoma, California, and about to be sworn in Georgia.
Fantastic.
Yeah.
Excellent. Yeah. And for folks who don't know Karen, she's like as humble as she is impressive, and just a remarkable trial attorney. Karen, how did you end up becoming one, a trial lawyer, and second, someone who focuses a lot of their practice on medical malpractice?
So admittedly, in law school, I had no desire to be a trial lawyer or in litigation. I thought I was going to end up in a cubicle reviewing contracts somewhere, which is funny to think about now because I would have been miserable. But I took a law clerk position at a medical malpractice plaintiff's firm in downtown Boston and helped out on my first trial. And that was it for me. I was like, this is what I need to be doing. This makes me feel alive. I'll figure out a way to pivot and do this. And I did. And so that's how simultaneously I went the trial lawyer route and also got into medical malpractice because that firm pretty much did 90% medical malpractice, 10% personal injury.
Yeah, and for folks who don't know and may have the misconception that Massachusetts is a really easy place to practice plaintiff's law because, the politics may be more left-leaning than in South Carolina. Can you just speak to whether or not Massachusetts is an easy jurisdiction when it comes to medical malpractice?
Yeah, it's not. I think you're right. There's a misconception a little bit about that. Massachusetts on our face, we're pretty liberal, but I think there's a lot of closet conservatives that
They
don't
all
like.
move here.
Yeah, exactly. But people who don't like to advertise how conservative they actually are in social settings. I think juries here, not to discount juries elsewhere, there are sophisticated juries elsewhere, but we have a really high population of, very highly educated, sophisticated people because there's a lot of colleges here. And a lot of people that come to college here end up staying around here. So you're dealing with sophisticated jurors, and then there's the added layer of we don't get panel voir dire as a matter of right. So we can request it. So prior to, I think it was 2016, you couldn't even request panel here. Then a new statute came into effect where we can request it, but the judge still has the discretion to deny it. And most of the judges here are terrified of panel because they aren't used to it. So the request gets denied more often than not.
Yeah, so South Carolina and Massachusetts are two of the only states, if not at this point, maybe only there might be one or two more out there. I know Maryland's had a lot of restrictions historically. We get it as a matter of the judge's discretion. So it's
Yeah.
do we have the right to it? We've got the right to the judge's discretion as to what's allowed. And what's happened here historically or traditionally is the judge did it, might ask a few questions the lawyer submitted, no real follow-up. If it's not broken, don't fix it. And now I believe there's a growing recognition of a better way to do it. But like you mentioned, I mean, there's also a lot of fear and uncertainty as to what exactly those alternatives look like. So if the easier path and the more familiar path is, if there's some questions you want, I'll ask them. If there's a follow-up, and I'll allow you one or two follow-up questions, and it's and it's strike your jury and panel your jury, and let's go.
That sounds pretty similar to here. Yeah, we have some judges who don't let the lawyers ask any questions at all, even follow up. It'll be the juror comes to sidebar, the judge asks some questions, the juror steps back, then we say, "Hey, judge, can you please ask XYZ?" The juror comes back and the judge is relaying the follow-up question. So it can be frustrating, especially now that I've been exposed to other states, like for example, Iowa, where it's unlimited voir dire most of the time. So jury selection can take days, but it's a very important process.
Yeah, and it's, what you'll hear sometimes is, well, we don't want to poison the panel, or we don't want to poison a pool. And it's like they're already poisoned. I mean, the
Yeah,
poison's
right.
already out there. We just need to figure out who has been uh so poisoned prior to arriving that we can't get a fair and impartial trial. But the poison's already there. I mean,
Totally.
what
Yeah.
are people going to talk about? How, lawyers are greedy and everyone hates car wrecks because of the ads they see on television. Me too. Like, me too. Some of my favorite TV shows, the only thing I don't like about them is like all the crazy lawyer ads. I get it.
Yeah. Yeah. Totally.
So what we're here to ultimately talk about, um, in terms of the real topic, is working with experts. And again, medical malpractice obviously lends itself, just by its very nature, to working with a lot of experts. You've done a great job navigating that world and probably have more day in, day out experience with it than most practitioners who aren't involved as heavily in medical malpractice. When working with experts, we can kind of start broad and then get more specific, but just in terms of general tips, best practices, things that have been successful for you.
Yeah. So I think one of the biggest mistakes I see lawyers make when it comes to working with experts, and whether that's medical malpractice or auto or construction, whatever the practice area is assuming they always know best and just relying on they're the expert, let them do their thing. I'm not going to question them or give suggestions. You really need to empower them like you would any other witness. And you need to give them the tools they need to succeed to help you win your case. So when I say empower like any other witness, you should be prepping them and giving them the rah-rah speech that you give your clients. Remind them what this case is about, what we're fighting for. Saying things to them like you're the smartest person in this room during cross-exam. If they go down this line of questioning, you know what the answer is. Don't get rattled. You know, be as nice on cross as you are on direct. The same things you say to your clients. Just because they're an expert doesn't mean they're necessarily automatically a great witness. So they need some hand holding and confidence boosting. And I think that goes for someone who's super green, that's never testified as an expert before, as well as someone who's well versed in litigation and trial, because sometimes those guys are really stuck in their ways and have, their little quirks or taglines that they might say, and you hear it on the stand and you're cringing.
Yeah. So Karen, let's talk about that a little bit. I know, I still struggle with, you've been an expert and it might be someone in their 50s, 60s, even 70s, and they've been around the block and they are a leader in their field. But to your point, they may have this thing, this tagline, this PowerPoint they want to use, whatever it is, and that's not what's most effective for your particular case with the particular jigsaw pieces that go around the expert's testimony to make the kind of whole picture. What have you found the most effective way to get them to maybe better understand their exact role in your case, and how they can help you win?
So I might be a little unique on this because I know some lawyers like the experts to stay in their lane totally. For me, if the angle they're using, I'm worried that the jury's not going to get it, or I want the message to be a little bit different. I try to come at it from a collaborative approach. Like, I agree with you, but you're so smart and you have all this experience and this makes perfect sense to you, but how do I make this so clear that I can spoon feed it to the jury? Like, let's talk about this. Let's brainstorm. Are there analogies you can think of that, would work here, or visuals we can use to help explain this concept? What I find is use a little bit of ego stroking, but also make it more collaborative as opposed to confrontational. If you start saying things like, I don't want X, I need you to do Y, that doesn't really get you anywhere. It needs to be, you're the smart person here. Help me deliver this message. How can we make this better?
Yeah, I think that's a great point because if you were dealing with, again, if it's your client or a lay witness, and you start telling them, say this, don't say that. Whatever you do, don't say this, but make sure whatever you do, you do. I've seen lawyers try that. It never goes great.
Yeah.
Um, really all you're telling your client or lay witness is, I don't trust you.
Mm,
I'm worried. I think you're going to screw it up. And they go in there back on their heels, feeling totally disempowered. Um, and just kind of thinking, but this lawyer doesn't like what I have to say. They don't trust me. It's not great for the rapport and the relationship. And I mean, think about how many times when you've been examining or cross-examining a defense witness, and they start talking to you in a way that they would have never talked
mm,
to defense counsel because you actually like engaged them and were genuinely curious in what they had to say and genuinely interested in who they were as a person. So I love that notion of really just approaching the expert witness prep the same way you would pretty much any other witness prep.
yeah. Yeah.
When it comes to kind of a nuts and bolts question, for the folks listening who want to make sure that they've got a system in place such that their expert, like you were saying, has what the expert needs to feel empowered so they don't get blindsided during any type of exam or cross exam. What do you do system wise to make sure the expert has what he or she needs well in advance of either deposition or trial?
So, um, for deposition, you want to make sure they have all the materials. Even things that you think might not be entirely relevant should be sent to them because defense will suddenly make that one thing you didn't send the most relevant thing in the case. Um, if you know the defense lawyers on the other side and you know their personalities, or you've seen them in expert depots before and they have a certain way about them, I'll tell the expert, this guy's a nudge or he's annoying. He's going to ask you the same question 100 different ways. Don't lose your cool.
I got to ask, what's a nudge?
Someone who's just annoying, a nuisance kind of
Got
thing.
it.
Yeah. They're gonna get under your skin and they're gonna irritate you. So I'm always having that kind of conversation with them. And just because they ask you the question over and over again doesn't mean you change your answer. The answer is the answer. Um, Always make sure if, it depends on state to state when expert disclosures are due, but always make sure they have the defense disclosures. And I'm usually asking them questions like, how do we lose this case? I have my list of things that I, go over with them as far as what I think our weak points are. But I'll ask them if the other side had hired you instead of me, how would you defend this case? And then we talk about, how we address those issues at the deposition.
Great
So yeah, so it's still a collaborative approach. And then, I think it's really important to talk to your experts before you depose defendants and defense experts too, because along that same line, a lot of times these experts know exactly what the defense is going to say, even if disclosures haven't been produced yet. And that's true for experts who have been around the block, and then newer experts who might be more academic and not well versed in litigation. They know based on literature, what issues are going to arise, and they can help walk you through it. So I think some people get an expert on board and they check the boxes, and it's like, well, I did my disclosure, I got the depot, they'll handle it. But you should really be collaborating with them more. And sometimes, they might bill you for it. Sometimes they might not. But I think at the end of the day, it's worth it, even if they bill you, because it's helping you build a better case for your client.
Yeah, yeah, and I love that it keeps coming back to collaboration, and really viewing it as part of a team effort. Karen, do you have any general rules in terms of time or timing? So for if your expert deposition's coming up, when you're kind of making your calendar or someone's helping you set that calendar, typically how much time are you taking to work one-on-one and collaborate with that expert in advance of a deposition or in advance of a trial?
Um, Depends on the case. So for most medical malpractice cases, I've done so many that I don't need as much lead time to prep with them. Um, if it's a complicated case in a different area that I haven't, had a decade worth of experience doing, I might spend a little longer. But for the most part, I'm meeting with them and talking with them a week or two before. It's not something I lead till the day before, but then I'll talk to them again either the night before or the morning of, just to remind them and give them the hype man speech about, you're going to do great, and remind them why we're doing this.
Yeah, because there's almost always, the day before, the morning of with the expert, where they always have the classic, I was going back through something and I noticed, and I'm
Yeah,
always hoping that I noticed is something that's helpful to us. Versus
yeah.
I noticed, and half the time it's helpful, half the time it's not as helpful. But again, being able to talk through that with them, to collaborate with them, just like any other witness, because they're just human beings. I mean, they've got all the other human stuff, and they're put in the same chair with the same rules, the same questions, the same everything as, your lay witness who's never testified, or the expert who's testified hundreds upon hundreds of times. When it comes to deposing or cross-examining defense experts, again, we can start more broadly and then narrow in, but in general, some of the best practices that you've seen and things that have been most effective when you're deposing or cross-examining defense experts.
Um, One of the things I was talking about with a colleague recently actually is, so I just had a medical malpractice trial in January. Got a $8 million verdict. It's 11.9 with interest out here.
Congratulations.
Thank you. Um, in that case, the expert was green. So the defense expert was not someone who had testified really before. It was a pediatric neurologist at Children's Hospital in Boston. He's like a world-renowned clinician, tons of publications. But in his heart, I could tell is an academic through and through. So with a defense expert, if I'm cross-examining them, I tend to be maybe a little more aggressive than most might be. Um, but because he was so green, I did a little ego stroking with him and asked some open-ended questions, because I knew as an academic he was going to have to agree with me on certain points. And it worked. It was actually really effective. So I think sometimes, again, you got to remember that these experts are still human beings, and try to gauge their personality. I think if I had come out of the gate really hot with him, it would have made me look like a jerk to the jury. So I think being a little more kind and open-ended with him worked to my advantage.
Karen, let me ask you, for a guy like that who'd been an academic, who was world renowned, obviously, I'm sure an incredible clinician who had helped a
ton of kids. What was it was a he or
Yeah, and the he, yeah.
what was his reason for getting involved in the case?
So, it was a complicated case. It was a tough case because the issue was a 13-year-old girl who had epilepsy and was already on anti-seizure medication, was having breakthrough seizures, went to the emergency room at Mass General in Boston, and they put her on another medication and started her at what our position was too high of a dose. The problem that we had to overcome was the FDA guidelines had recommended the dosing that the defendants gave.
Even if they're on the other medication to help control?
Yes, and so even though our client was 13, she was the average weight of an 8 or 9-year-old because she was 60 pounds. But the FDA guidelines said if you're over age 12, don't factor in weight. Yeah. Yeah. So it was an uphill battle. So I think it was easy for him to support the case given the FDA guidelines. He could just say, you follow the guidelines, period, the end. I also know, but it couldn't come in at trial, that the defense lawyer represented him in 2 other cases. He has the same malpractice insurer as the defendant did in my case, but none of that comes out at trial.
Got it. And none of that came out at trial because of legal rulings from your trial judge or because of specific evidentiary rules, or I guess
Yeah,
a
a
combination
little
of
bit of
the two.
both. A little bit of both. Yeah.
Yeah,
Yeah.
yeah. Um, yeah, I mean the malpractice carrier makes sense. I was thinking about the prior claims. Okay, so again, like I mentioned, we could always veer off from the talk on experts. Now I'm super curious as to how y'all proved a violation in standard of care when they followed the FDA guidelines.
Yeah. So this might be the only med mal trial I've been involved in where we were really hammering clinical judgment. Usually the defense is all about clinical judgment. And a big point was this isn't one size fits all. This isn't, assembly line medicine. You don't just look at the FDA guideline and say, well, my work here is done. You got to look at the patient in front of you, treat her like an individual. She deserves that. And think about, how this can affect her. And a big thing that helped us with that is there was black box warnings about starting at too high of a dose and how it can cause Stevens-Johnson syndrome, which is what she had. I don't know if the average person listening knows what that is, but if you want to be horrified, Google it. It's a rash all over your body that, targets mucous membranes, so eyes, nose, mouth, genitalia, and essentially causes the skin to slough off. It's an awful, awful, awful syndrome.
So another question, again, this is from someone who doesn't do a ton of medical malpractice. All right, so you've got FDA guidelines in place, but you also have a black box warning. How are those reconciled?
Yeah, that's a good question. I can tell you I'm very frustrated with the FDA after this trial. I looked into, and this goes along with the experts too. I looked into all the clinical trials that supported the guidelines as of 2013. Not a single clinical trial had tested that dosage on anyone under the age of 18.
Wow.
So it seemed awfully arbitrary for what the guidelines were. Um, but the black box warning was basically like, hey, provider, you should know if you start at too high of a dose, it can cause Stevens-Johnson syndrome. But it didn't specify what, too high of a dose is.
So what should they have done? Like they
So
did it the wrong way. What's the right way?
yeah, so they started her at 25 milligrams of this drug called Lamictal, and it was our position that it should be started at 4 milligrams based on her weight. And then you gradually titrate up and see how she responds to the medication rather than just starting her off day one at an adult dose.
Got it. So she obviously suffered terribly. Did she survive?
She did. She is blind in one eye, has no eyelashes, and she has scarring in her vagina that's going to require reconstructive surgery at some point. Fortunately, the scarring from Stephen Johnson throughout her body has resolved for the most part, but she's lost her vision and no eyelashes and in her tear ducts, which to me was like the most frustrating thing. I could not imagine being sad or frustrated and not being able to have that cathartic release of crying. She never gets that.
That's horrific.
Yeah, yeah.
Did she attend any part of trial?
She did. She was there for the whole trial. So was her mom. She was 13 when this happened, and she was 24 at trial.
24. Had it gone up and down on appeal or something? I'm just trying to
No,
tell we got 11 years in.
MedMal moves slow here, is part of the problem, and then COVID also caused some hiccups too.
Yeah, we had a case in Virginia that ran in part because of COVID, in part because of a bunch of things, like 7 or 8 years. It was crazy. And
Yeah,
the lawyer and I, or the lawyer we were working with on that case up there, it was like, we knew each other when we were young.
yeah, yeah,
Okay, so in that case, that was one type of expert, and this was a green expert who was academically inclined. Um, Karen, what do you do with, and I've heard Keith Bruno talk about kind of the breadth expert, the person who they might testify in a back case, a shoulder case, a knee case, a this case, a that case. They're just like they are somebody's sweetheart or somebody's sweetheart. What do you like to do when you've got an expert who is that Jack or Jill of all trades, but perhaps master of none?
yeah. I'm definitely going through and trying to find as much material as I can to impeach them. That's the beauty of someone who testifies a lot. There's probably a lot out there on them. So whether that's Westlaw or, local trial associations, emailing on listservs, trying to find depot transcripts, expert disclosures, and, don't limit yourself just to your state because a lot of these guys are testifying everywhere. And with someone like that, so I'm establishing, how many times they've testified, what type of cases they testify in, and I'm more aggressive with them because you don't want to give them much wiggle room. But I find with a lot of experts like that, if you ask even the most reasonable question, they're going to find a way to disagree with you. And that usually doesn't sit well with a jury. So you might even want to dumb down concepts to be, as simple as possible, something that no one could possibly disagree with and see how they handle it. And then you'll know in the moment if they've said the thing you needed them to say. Take a long pause, look at the jury, like, really, you know. Um, but those guys get themselves into trouble too because you say sweetheart, I use a different word, but
Different kind of sweetheart.
yeah, yeah,
Yeah, and they're always slick. They've always got an answer.
yeah,
It's never a good answer.
no,
It's just made up as they go,
yeah,
which is really a shame. When you're coming into a case later, kind of going back to your own experts, when you're coming into a case later, if you see that, perhaps there's an expert or multiple experts that as you really look at the trial presentation, you're probably not going to want to call. What's that conversation like uh, with co-counsel, especially if it's someone who, let's say it's a life care planner who's put together a very large life care plan, and then looking at it, you think life care plan hurts the case. Life care planner's testimony hurts the case. Walk us through what those conversations, how you approach when to use and perhaps when not to call an expert.
yeah. So I mean, this happened in a case recently where there was a life care planner and an economist, and um, I felt as though uh, it wasn't very credible. So I had that conversation with co-counsel about, we don't need these people, and here's why. I think it might hurt our other claims, for non-economic damages if we're trying to nickel and dime economic damages that aren't really there. And the reality is that the non-economic damages are worth way, way, way more. And it takes away from our story, and it gives the defense an opportunity to attack our credibility. So, credibility at the end of the day is most important, obviously. People inherently don't trust plaintiffs' lawyers at baseline, so we don't want to do anything to jeopardize that. I found most co-counsel has been totally receptive to it as long as we explain the why, as to why we're doing it, and talk about what it would look like at trial if we did call these people. So I haven't run into any issues where anyone's really strongly disagreed on it.
Yeah, same. And I love your explanation and rationale. It's just like, again, very, very familiar. Because if it doesn't help,
Yeah.
hurts our credibility, and it lets the defense make the case about something that we don't want the case to be about anyways. Let's get rid of it.
Yeah, totally.
Let's ditch it. Rebuttal experts, is that something that you've used, that you have found value in? What are your thoughts on rebuttal experts?
So in Massachusetts, we never got rebuttal experts. So that was new to me once I started practicing outside of Mass. I will say in Iowa, we use them pretty frequently. I found that they can be helpful, not necessarily always needed. For a lot of these cases, we can anticipate what the defense is going to say. So it's usually covered, whatever the rebuttal issue would be in our first disclosure. But there's been times where we've utilized rebuttal experts for sure.
And Karen, working our way to closing and rebuttal itself, what are your general thoughts on kind of the role that you're wanting to highlight the experts played during the trial when you're getting to closing or rebuttal? I mean, I'm sure it's a case by case, but for example, in the Massachusetts case that you were describing with the young woman, is there anything that your experts testified regarding that you really want to highlight or accentuate in closing? Anything that came out during cross-examination of defense experts that you really want to call attention to, and kind of the interplay between those aspects of your closing and any broader themes in the case? And that's a long question, but
yeah, no, I got you.
You got it. Yeah.
So one of the things I definitely highlighted in the Massachusetts case, so we don't have rebuttal closings here, so plaintiff just goes last. But and this goes back to what I said earlier about, giving the experts the tools they need to succeed at trial. So I told you about how I went through all the clinical trials regarding that one medication. So I went through them, highlighted key things, made a summary, sent it to my expert, who's also a pediatric neurologist. And I was like, I want you to be able to say on the stand, you reviewed all these materials. So please go through this. I've highlighted these things. And he did. And so when he was, on direct and cross exam, he was able to say that and talk about specific things that, he gleaned from the trials and how this dose hadn't been tested in any of the trials. And the defense expert, which I blame the defense lawyer for inadequate prep on this, admitted to me that he didn't look at a single clinical trial. So that was something I definitely highlighted on, slides in my closing. Any chance you have to boost your expert's credibility, you really want to capitalize on that. And as far as, maybe it's a little too much, I don't know, printing out all the clinical trials and going through it, but I think too often people assume the experts have looked at all the literature and have done all the things. But spoon feeding them material that's going to help you is ultimately going to help your client. And drawing their attention to things like literature or textbooks or whatever it may be is only going to help. And it makes them feel more confident in what they're saying too, because it's like, look, I just found this article that backs up completely what you said, So in closing, I'm trying to highlight credibility issues for sure.
Yeah, I think that's fantastic. I mean, what stands out to me is when you saw that it met the FDA guidelines, you didn't say, oh, damn, phew, okay. It was like, well, hold on now. What were the clinical trials the FDA relied upon? They didn't actually do any trials on people under the age of 18. I mean, for me, like just hearing that, like I immediately now throw out the FDA guidelines.
Yeah.
And the question that popped up in my mind was, I wonder if the physicians who were ordering the medication to be administered were familiar with any of the clinical trials and aware of the fact that none of those trials were done on people under the age of 18.
They weren't. Yeah.
And if once I hear that, I'm like, all right, how much you want? It's kind of like for me, that's
I mean, maybe that's what did it. I don't know, but I think it certainly helped.
Did you talk to any of the jurors afterwards, or are you allowed to talk to jurors afterwards in Massachusetts?
You can if you file a motion, and then you have to give the defense an opportunity to oppose the motion, and then they have to be copied on the communication. So
Guess is you didn't make that motion.
no, no, so not ideal.
Yeah. Yeah, I think that's one of those. Thank y'all.
Yeah.
Yeah. Karen, when it comes to working with experts or cross-examining experts, what have we not talked about that you think's essential for folks to know
Um,
or important for people to know?
I don't know. I think just going back to what I originally was talking about of treating them like a normal witness. Sometimes that includes attire. Sometimes that includes, demeanor in the courtroom. Where they're sitting in the courtroom, I don't want them looking like part of the legal team when they're in there. I don't want them sitting next to my client. And some of these, and I could share some horror stories of what experts have shown up to court dress like, and lesson learned quickly. And you don't want them, if it's a physician, you don't want them showing up with a white coat on and their stethoscope around their neck.
Stethoscope, yeah. Yeah.
So, I think things that you think might be super straightforward and already understood, don't assume.
You want the expert in the courtroom at any point before they testify, or do you want them waiting out in the hall and you or someone from your team getting them when it's time for them to testify?
If they're allowed to be in the courtroom, I don't mind them sitting there as long as they're sitting in the back or something. But most courts don't allow the experts to be sitting in there. Although there was a recent trial, I wasn't physically there in Wyoming, but was helping out Courtney and Jacob while they tried the case. And the defense had their experts in there. It was like 3 or 4 days in a row, all of them sitting together in the back of the courtroom. I don't think that's a good look. And they're getting paid to sit there for days on end. If it's
That's
a
still
situation like that, you don't want them there.
yeah, I mean, it just kind of lends itself to, hey, those days that y'all spent sitting back there, were y'all ready to get your story straight? I mean, it just
Yeah,
feels like a
right.
real, let's make sure we tell the teacher which tire was flat.
Yeah, like what are these powwows that are happening back there? Yeah.
Weird. Listen, thank you very much. It's always good. It's always good seeing you, spending time with you, learning from you. Um, what's coming up on your docket in terms of additional trials in 2025?
Well, I'm currently 36 weeks pregnant.
Oh, congratulations.
Thank you. So next plans are maternity leave.
Take a long maternity leave. It's not that I was unfair about maternity leave before my wife got pregnant, but then after watching her go through pregnancy, I was like, whoa, like we could be more fair and understanding and what women go through, at least from where I sit. And again, it's like I just didn't appreciate nearly as much as I should have. So I hope you have wonderful time off and just an incredible, incredible time with your family. It's certainly well deserved.
Thank you. And I'm gonna praise Nick and Courtney a little bit here because if I was working at a different firm or the firms I was at previously, I'm not sure that I would feel comfortable taking leave at all. They have been so supportive about it. They've been telling me to have babies like since the day I met them. So, yeah, so I'm lucky to be working somewhere where I can really, take that time off. I know not everyone is as fortunate.
Yeah. Yeah. I think having a kid made me a better lawyer. Uh, Certainly on like certain types of cases. We were meeting with a family earlier today, and their daughter had been killed by a guy who was like experiencing a drug psychosis. And it's not that I couldn't do a good job for them before, but going back to kind of golden ruling myself, putting myself in their shoes and thinking through it, it's with a child, um, it's both harder because you don't want it to feel it, but easier because you can. Uh, and I think for as amazing an attorney and advocate as you are now, you're only going to be better um, once that beautiful little girl comes into the world.
I think she impacted my verdict in January because I was 6 months when I tried that case, and I think I had a more visceral reaction to things, and was definitely more emotional than I think I ordinarily would be because it's like, what if this was her? You know,
I just wait till she gets here.
I know, yeah.
I'm so excited for you. I'm
Thank
so
you.
excited for you.
Thank you.
Um, okay, so that is way more important than work stuff. Um, when you get back in office and when folks have medical malpractice questions, really for any of the many, many states in which you're barred or any of the states across all 50 United States, and want to be able to get in touch with you, what is the best way for them to do that?
My email is my first name, so it's Karen, Karen, at TL4J, number 4J.com.
Karen, thank you again for coming on. Like I said, it's always great spending time with and learning from you. I'm even more excited knowing that you're getting ready to become a mom and be even more of a freaking legal powerhouse and just amazing advocate for other human beings. Uh, and yeah, I very much look forward to seeing you soon. Thank you.
Yeah, thank you so much for having me. I always enjoy talking to you.
Yeah. And for all our listeners, again, our guest today has been Karen Zahka of Trial Lawyers for Justice, a renowned medical malpractice lawyer. Um, Reach out to her and work with her and wish her well on her little one very soon. And thank you all for listening. Take care.